Welcome to the Law Chambers, where legal matters are discussed from a Christian perspective. The name is Anita Delight. Episode 9 already. 9. Hey, yeah, dear, 4 months ago, and then we'll be done with season 6. So today we are going to discuss RTI. Only RTI, don't worry. We'll go into it very soon. And as usual, if you have any questions, you can go to our Facebook page or ask all the questions away, and we'll ensure that it's answered. And then you can also ask your questions on 0559 680066. 0559 680066. And sit, relax, and let's enjoy ourselves. Okay. I'm hoping that this information will be very helpful, not to just institutions, but to individuals who are very curious to know really what's happening in Ghana. Okay, so I have 3 guests, and my first guest is Mr. Seth Joseph Bokpe. I'm hoping I'm pronouncing the name right. If
I hope you've not broken the jaw.
Seth, you said I'm not what?
I hope you've not broken the jaw.
I'm not what? I've not broken it.
Your jaw.
Oh, thank you so much. So, Seth is a multiple award-winning investigative journalist with over a decade of experience. His specialty includes environmental reporting, health reporting, anti-corruption reporting, fact-checking, and data. He's a data enthusiast. He is currently the associate editor at the Fourth Estate. Seth has worked with several institutions, including Graphic Communications Group Limited, African Watch Magazine, and has also worked as an intern with GBC. Me, I just say someone making and he's asking himself where am I getting all this information from. Seth obtained his BA degree in Communications and Media Studies from GIJ. He holds a Master's in Development Communication from the University of Media, Arts and Communication, and a certificate in Balance Scorecard from George Washington University, USA. Seth loves to volunteer, and in that capacity has worked as a public relations officer of Journalists for Human Rights, Team Journalists for Daily Graphic Ghana, and Media Relations Mentor Role Model for the Zongo Inspiration Team. Seth loves to play football, and he loves to listen to music. Seth?
Hi.
Where did I get all the information?
Hey.
Me too.
I said I'm an investigative journalist. So you investigated me.
I'm telling you, I've done investigative journalism on you to get all the information. You are very much welcome.
Thank you very much, Eli.
All right. Then I have with me a lady, Francisca Enchel. Francisca she's also a multiple award-winning investigative journalist, and she works with Corruption Watch Ghana, and she's had over 15 years of experience. She's a full-time consultant with the Ghana Center for Democratic Development, that's CDD Ghana. She was the first female winner, the first ever female to be awarded the Best Investigative Journalist of the Year award in 26 years by the Ghana Journalist Association. So she knows her job. She's into investigation, research, development, and documentary production. You hear all about Francisca, okay? And then, last but not the least at all, is my senior counsel, lawyer Stephen Owusu. Lawyer Stephen Owusu, he is a lawyer and the head of the legal department of the RTI. Remember, some kind of foods. He's also an adjunct lecturer at the University of Professional Studies. He's a former student of Prempeh. How I don't like them, former student of Prempeh College at KNUST, where he did his English and the law, and then of course he went to University of Ghana to do his LLB, and then Ghana School of Law. He's also an alumnus of Columbia University in New York, where he obtained his master's in law. Prempeh boy.
Yes. I'm on for.
Oh, Jai. My husband is also Prempeh, so that's why I don't like Prempeh.
You go for the best.
I do. All right, so let's zoom in and let's go so much into it. So I've been saying RTI. I think, what is RTI? Do you have any acts backing it, and how effective has it been so far?
Thank you very much, Anita, and good evening to your viewers and your listeners. So RTI simply means right to information, and it is a constitutional right. is one of the fundamental human rights enshrined under the 1992 Constitution, specifically under Article 21, Clause 1F. Now, the whole of Article 21 deals with general freedoms. So one of those freedoms enshrined therein is the right to information. So Parliament needed to pass a law that would show how people could take steps to enjoy this constitutional right. So there is a law backing the right of access to information. One, it is a constitutional right. It's one of the fundamental human rights and freedoms we enjoyed. And then two, Parliament passed a law in 2019 called the Right to Information Act, Act 989, which law shows how people can take steps to enjoy this fundamental human right.
So the RTI is right to information.
Exactly.
Right. So what are some of the rights? Can you use some of the basic rights?
As in aside the right to information?
The right to information within it, what are some of the rights within? Is it every information, any information?
Okay. It is certainly not all information that could be given out. When you go under the RTI Act, Act 989, there are classes of information the law has described as exempt. Exempt to the extent that for those classes of information, when you go and ask for them, the framers of the law say they cannot be given. So they are exempt from disclosure. And those classes of information are spelled out from sections 5 to 16 of the law. Okay. So we have a wide array of information that the law identifies as exempt. And in fact, let me hasten to add that conferring with sister institutions from other jurisdictions, they seem to have concern about how wide the exemptions are. Okay.
Ours is very wide.
Yeah, of course, as I said, from section 5 all the way through to section 16.
What are some of them? Is it like intelligence? Is it security? Is it?
Okay, so when you look at all the exemptions, okay, you can deduce that information that borders on national security cannot go out. Information that is personal to people and to institutions, information that will protect their economic rights can also not be given.
That's quite ambiguous. So in terms of personal, if the person is a public figure, where personal...
Okay, so Anita, we need time to go through to go into that. The personal information is under section 16 as one of the exemptions. And what section 16 actually says is that information, the disclosure of which would reveal the personal affairs of a person, whether living or dead, is exempt where the disclosure is unreasonable. So there is a test there. There's a test there. Unreasonability.
And it does at the discretion of the court? Or the giver?
The institution. The institution. Okay, but the Act gives a peep into what may be considered reasonable disclosure or unreasonable disclosure. So when you go under section 16.2, it says that information relating to the personal, mental health, physical and mental health of a person, such a disclosure is unreasonable.
When it will affect the work of the person?
No. Okay. Information which would reveal the physical and mental health of a person.
So let's say the person is a chief justice.
Yes.
Or the person is a police constable.
Yes.
And that mental or physical will impede the person's work.
Yes.
And I'm asking you, because I've seen something, so I'm asking you whether that person has that impairment. You're not going to tell me when that can impede the work of the person?
Yeah, the yardstick there is reasonability of the disclosure. So I can give you an example. Okay, I can give you an example. Now, who's been using this example? Because when you go under section 16.3, it also gives a peep into disclosures that the law would deem to be reasonable. Okay, so let's take, I'll use myself as an example. Okay, So I arrive in Ghana with a strange strain of COVID. Okay, so upon testing at the airport, it is found. And I have to be quarantined. Okay, so this is information that bothers on my physical health. Okay, so under section 16.2, we would say that disclosure will be unreasonable. Now, if Anita should apply to Ghana Airport Company Limited, that I've heard that somebody by name Mr. Stephen Owusu, okay, came in and he tested for a strange strain of COVID. Okay, so I want information on that. Would the disclosure be reasonable? As against Ghana Health Service applying to Ghana Airport Company Limited for the same information. You look at the two and you realize that disclosure to Anita could be unreasonable, but disclosure to Ghana Health Service would be reasonable.
That's true. Looking at the circumstances. Now let's change the scenario where I've come into contact with you.
Yes.
Okay. You knew you had the disease.
Yes.
I've come into contact with you.
Yes.
There's a possibility that I might have the disease. Someone steps on my toe that this person was go to airport and ask them that question, because there's a possibility that.
Why don't you go and test?
I want to be sure that you have it or you don't have it.
You don't even know. You don't even know that the type of ailment I came in with. Somebody is telling you that there's a possibility that I may have infected you.
Yes. So you go to the hospital and go and test.
You haven't tested. No. So if you find out, and assuming it is reasonable for this information to be given to you, how would that inure to your benefit?
I'll see you for endangering my life.
that is there. Okay, that is there. But as I said, okay, if you feel,
I think I get you.
Yes.
I think I get you, because all things being equal, people's rights should be protected.
Exactly.
Their personal information should be protected.
Yes.
So if it will not inure to your benefit, and all things being equal, why should we tell you about it?
So exactly. And if you want to go under when you go under section 16.3, okay, it for instance says that if the information being sought is the personal information of the requester, then of course giving out such information is reasonable.
My own, my
own
information. So.
Yes, okay. But then also, it is also reasonable if the person whose health information, okay, it is, has already put out that information.
Okay.
If somebody comes to ask for it, although it would have been unreasonable to give such information under section 16.2, because it is information that reveals something about the person's physical health, but the person has already put it out there. So within this particular circumstance, when you give out that information, it is reasonable. But that is just one of the exemptions.
So we are looking at security, we are looking at personal health.
Yes, the personal information. Okay, we are looking at information relating to tax liability.
Tax liability?
Yes, when you go under section 12 of the law, it says that information that would reveal a person's tax liability is exempt from disclosure. What if I'm in business, I want to go into business with that person is not giving me all the information, and I'm informed that I could get more information? But
what, Anita, if I may ask, you want to go into business with the person, and your concern is that the person does not pay tax.
Yeah, it's important, yes. To me, the person is a law-abiding, the company is a law-abiding, and they are not paying tax. So if all things being, are going to, if you do the measure or you do whatever it is we want to do, at the end of the day, their liability becomes my liability. Why would I want to go into that?
So you see, if you want to know how much tax the person has paid, we can draw a line. That's a liability.
I want to know their liability.
But, okay, but the liability is the debt owed by the person.
But that's what I want to know. If the person is in debt.
The law says
that's an exempt.
Yes, it's exempt. So at the commission level, generally we've not been allowing tax clearance certificates out. Because when you pick a tax clearance certificate, for instance, you have figures on it. And any astute business person, okay,
On the face of it.
yes, on the face of it, can know and can gauge how well a person's business is doing or otherwise. And if a person is a business rival, okay, it may not be good. Okay, so that is also one of the exempt classes of information. And go under section 13, it talks about internal working information.
Okay.
Okay,
That
internal
makes sense.
memos,
Yeah.
emails,
Yeah.
those pieces of information are exempt. We can also talk about information relating to law enforcement and public safety. So this is where the security agencies can take over. We can talk about Section 9, which deals with information relating to national security. Okay, that is
All
also
the
exempt.
security.
Section 5 deals with information prepared for the consideration, deliberation, or advice of the president or the vice president, of the president or vice president, and where giving out such information has the potential to prejudice whatever deliberation may be going on.
Okay, so
or
that's
prejudice
a caveat.
Yes, that's a caveat.
So if that caveat is not there, all things being equal, they should be able to give you that information.
Yes. Okay. Yes. It applies to cabinet also. Section 6 also deals with information prepared for consideration of cabinet. But even with the information prepared for the advice, consideration, or otherwise of the president, vice president, or cabinet under sections 5 and 6, we have provisions there that say that, but where such information is factual or statistical, then it is not exempt.
I think I like that.
Yes.
I think I like that bit.
Yes.
Because if it's factual, why will you? Seth,
Hi.
so far so good.
So far, not too good, particularly with reference to the exemptions. I mean, for a journalist, we are particularly concerned about the broad range of exemptions that, deny us information. Some of this information that has been labeled or tagged as national security information do not really qualify to be classified as such, if you ask me. If you take, for instance, there was a request the Port Estate made of the presidency in 2021, I believe, 2021, 2022, about the then president's expenditure on private jets. I mean, and where he had flown to. This is information. This is something that had happened already.
And
The
it's
president
factual.
had flown out of the country. His itinerary, part of his itinerary was posted online by his director of communications. And we asked for these details, and we are told that we did not demonstrate public interest enough for the RTI Commission to direct the presidency to release the information when they refused to do so when we asked them. I think that was a bit unfair, and then also not forward-looking enough, because you have a situation where you have public expenditure being questioned on something that eventually the president stopped doing because of public uproar. If it wasn't public interest, why would the president stop flying on the private jets after the public got angry with it? That is one. Two, my co-panelist spoke about taxes, information related to taxes. I mean, we are in an era where illicit financial flow is a big problem. It's a major problem. And we have companies evading taxes left and right. And the GRA will tell you, oh, we are open to whistleblowers alerting us about people evading taxes. But how do we as journalists verify that information if the custodian of that information is not willing to release it?
But they are
Did you get
saying
it?
that
The
tax they are
GRA is
looking
not
at-
willing to release information. The GRA is not willing to release information about the tax payment status. We are not asking for how much you paid or how much you owed, but your tax payment status.
But that's
I don't know
impossible.
how that qualifies to be an exempted information.
Now that should be possible, Seth, because what Stephen is talking about is tax liability. So tax liability, no, they can't. But when it comes to tax generally, there should be.
Unfortunately, consistently, the Ghana Revenue Authority has refused us information on tax status of these companies. You ask and you are told this is exempted information.
And we brought it to the attention of the commission.
If I may come in here.
Okay.
Okay, so Seth, I've handled, at the commission level, I've handled a number of, I think Seth in particular, I think Seth has come to the commission a number of times. Okay, but
he's always in my office.
I'm here to see any complaint regarding denial of access to information by GRA regarding what he's talking about. Because as I said, what the law says under section 12 is where the information would reveal the person's tax liability. Okay. As we speak, even today we had a meeting with GRA over a similar request by another applicant. Okay, I wasn't in the office, but I was aware the meeting was coming on, and our position is clear. It is tax liability, okay, that the law has exempted, but not records regarding how much tax the person has already paid to the state. Our position is clear on that. And then coming back to the first complaint raised about the cost of the president's travels, I think that application was made by Manasseh on behalf of the Fourth Estate. Yes, Manasseh went under Section 17. Okay, disclosure for the protection of public interest. Okay, so let me put issues into perspective. Yes, a lot of people think the exemptions are too many. Okay, because right from sections 5 to 16.
I think we all agree on that. It's quite
yes. Okay, but I've also been drawing attention to the fact that perhaps we have not been paying attention to the effect of Section 17. Because immediately after the exemptions in Section 16, we move on to disclosure for the protection of the public interest. And when you look at Section 17 critically, it undercuts all the exemptions. Because what does Section 17 say? Section 17 simply says that in spite of all the exemptions, where the information requested is exempt, okay, but the disclosure is to protect the public interest, then it can be
that
disclosed.
exempt will be exempted.
Yes, it can be disclosed. So I've always been quick to draw attention to the effect of Section 17.
But what Manasseh was asking for, frankly speaking, is information that should have easily been given out.
So you see, I feel a bit constrained discussing because
I don't want to put it will not be fair to you.
No, we did. When I say we, I'm talking about the commission. We did a 19-page, decision on it, reasoned decision. Okay, so it will be very difficult just to pick, portions of it.
But it was agreed that information cannot be given out.
Yes.
Based on article section 17.
So he came under Section 17.
So if he had not come under Section 17.
No. So he came under Section 17. That he was requesting for the information, in exercise of his function as a journalist for the protection of the public interest. Okay. So he came under Section 17. Okay. And coming under Section 17 presupposes that he himself knew that it would be exempt. Is that not the case?
Yes, but
that wasn't a reason for saying.
Because generally looking at the exemptions and its nature, this doesn't look like something that will be exempted.
So you see, the cost of the president's travels. Okay, we also do our homework
because
as a commission. Okay, we also do our homework. That cost forms a component of the budget of the National Security Ministry.
Oh, you went at that security.
Okay, no. So you see, Seth knew. that issue had even been raised in Parliament. Okay? And the then Minister for National Security, Honorable Albert Kandapa, had been.
But we all know that usually
summoned.
when people don't want to answer questions, they will go under security.
No, but that was
But
the
looking
reality.
at it on its face,
Yes.
in the proper context, you can decide that it doesn't qualify
we
for security.
we considered it not only from that angle. That is just a small angle. That was how I said it would be.
And I don't want to put you on the spot too much on this because it will not be fair to you to put you on the spot.
I know the decision, but you see, we considered it from different. But this is just one small angle. Okay. Section 17. When you say you are coming under Section 17, okay, the cardinal yardstick there is the protection of the public interest. Okay, how do we measure that? Is it the case that I can stand up one day, request for any information which I know to be exempt, and say that I'm coming under Section 17 because I know that this disclosure will serve the public interest? How do we gauge that?
But frankly speaking, that information.
But Chief, hello.
Yes.
Can I step in?
Yes, come in.
I'm wondering if Section 17 talks about statistical and factual data being not being exempted.
Yes,
Why
sir.
then do we say that because it is national security, it's exempted? If you even check Article 18.2 of the Constitution,
Yes.
it gives a broad range of conditions under which
Privacy.
one can actually invade the privacy of a person. And I don't think that, that includes public interest as well.
No, but that's exactly the point.
That range
Okay, that's exactly the
includes
point. You need to get the
public
decision.
interest.
Anita, you need to get the decision. It's a 19-page decision. Okay? And then know the reasons the commission based on to reach that conclusion.
I think asking for, and I think the commission was unfair when its carte blanche said this is national security. When, for instance, we asked for places the president had traveled to, and this had happened, the president, director of communications, had published this on his Facebook, part of this information on his Facebook page. Mr. Stevens mentioned that if that information is already in the public domain, then it is not exempted. In this instance,
It's not exempted for
Okay,
bringing the
let me
personal
bring
information.
the lady in. Let me
Okay.
bring Franca in. Hey, the gentleman don't kill me. Franca. Francisca, hello. Please unmute yourself. If you've muted yourself, please. Hello, Francisca. Can you hear me? Francisca, we can't hear you. If you can unmute yourself, please. Okay, Francisca,
Can you hear
coming.
me?
Yes, thank you so much. So, Franca, you've been
Can you
here
hear
a
me?
gentleman, but I want your perspective in respect to trying to get information, practical example, as in trying to get information, and how has it been in respect to the RTI? Has it been helpful, the Act?
The truth of the matter is I haven't really worked with the RTI law that much compared to how SET has extensively worked with the law. And I just recently started working with it, and it's been frustrating. That is how I can describe it. It's not something that I'm used to, and the restrictions, it's a bit frustrating because it kind of holds your story. Because when you send the request, and then they are given that 2 weeks, and then some of the institutions deliberately sit down and they are waiting for the 2 weeks to elapse for you to send to the head of the institution. And even one of the institutions I wrote to recently were actually reading the processes to me. In other words, they were going to drag me through the processes. They were not in a hurry. And the only conclusion I can draw will be the fact that I think that, yes, we do have very beautiful laws in this country, but then there are a few gaps in the implementation of these laws. And I think that there are certain aspects of the law that needs to be looked at. Because when you look at the frustration, within the short period that I've tried using the law and how I've felt, I just wonder what Seth has been through this whole time. And when you look at the frustration, I can only draw a conclusion that it is because no one is personally being held responsible, and so there's no urgency to deliver information. Because at the end of the day, if they do not give you the information and you even find the institution, it's not coming out of anybody's pocket. It's going to be our taxes that are going to be used to settle this money. So it's like the state paying the state. Nobody suffers at the end of the day. If, for instance, the RTI officer is going to be directly paying for this if he does not release the information, or he and his boss are going to be surcharged to personally pay penalties for not releasing information, I think the way the law would have been handled would be much, much different. So that is the only conclusion I can draw within this short period that I've tried using the law, because it just holds your work down as a journalist. You want to move at a certain pace, and then the RTI process is also moving you towards a different direction. Sometimes the provisions in the law, the duration they've given, then the institution writes to you and then requests for more time. You sometimes write to them, do the second follow-up, and then now when you petition the RTI Commission, these institutions will be going back and forth. In fact, my colleague has been following one case for from somewhere since February. He has still not received the information. He's taken it to the RTI Commission. It's been back and forth, and it's been back and forth. I think if somebody is personally being held responsible, things wouldn't work this way. So for me, I think the essence for which this law was introduced has not been met.
I think I agree with you in a way. Yes, I think I agree with Franca in a way that, because at the end of the day, if the institution fails to comply, it's the institution that pays. So there's government to government instead of the individual taking liability.
Let me come in here, Franca. I think that is too blanket a statement. You can ask Seth, and I knew. Okay, Seth is not the only one who has raised issue about the decision in the president's travel case. But aside that, you can ask Seth. We've been dealing with the Fourth Estate right from the beginning of this law. But the Fourth Estate set out to test the law right from 2021.
Yeah.
Okay, and they will attest to the fact that the rate at which the commission has helped them get information is very high. Let's take the president. That one we can argue over that. But we dealt with Seth, we dealt with Manasseh a number of times. We dealt with Kweku Krobia, we dealt with Vance Asiamo, and they all attest to the fact that when they come to the commission, we do everything possible to make them get the information. Now back to Franca's concern. So you see, if you go, there are timelines under the law. Okay, when those timelines elapse, you have to come to the commission. And so if you have not come to the commission, it is a bit unfair for you to say that the act is not achieving its purpose. That is why when you go to the public institution, within 14 days, the public institution has to take a decision on your application and serve a notice. Okay, if the public institution needs additional time, the law says that the head can only grant extension by 7 days and notify you. Okay, so in the case where the institution needs additional time, it's 7 days plus the original 14 days, making 21 days. If you do not get the information, you trigger the internal review. But even if it is the head of the institution who signed off the initial decision, that gives you the opportunity to come straight to the commission. I'm not sure which case Franca is referring to, which has been at the commission. I don't know how long it has been at the commission, because when it comes to the commission, we work internally, administratively. We have timelines we work with. Okay, yes, I agree. There are times that there could be back and forth. Okay, some back and forth. But in most instances, you're able to get the information for the applicant when they come to the commission.
Yeah, I think one of our institutions. Yes, Franca.
Yeah, so for the case that I'm talking about, I can't mention it because this is still something we are still working on. So it's not something I can mention on.
No, but is it at the commission yet?
Pardon?
Is it at the commission yet? Is it at the Right to Information Commission?
Yeah,
yet?
it is at the commission.
And
yes,
for how long?
It's at the commission.
How long
yes.
has it been there? Because I'm head of legal.
It's been there for a couple of months. There's been meetings between us and then the institution in question and all that, but still we've not had the information we are looking for.
Yeah, so once
we are working
so once there are meetings, the Act also enjoins us to employ ADR means. So there are times, in fact, and currently we are using ADR more than the exchange of correspondences because we realize the mediation tends to be faster. So there are times we have to invite the parties. We sit, we thrash out. Okay, we listen to the concern. And the last time I met somebody from Fourth Estate, I think it was Kwaku Krobia. Okay, and then he agreed. We met, we sat in the middle as a commission. We listened to what the challenge was from the public institution, why they had still not been able to respond to the application, forcing the applicant to come to the commission. And upon explanation, they understood. So we all agreed on timelines. So we use ADR means, particularly mediation, to expedite processes at the commission, just so that persons can get the information they have applied for. So if there have been 1 or 2 meetings, it is all part of the efforts we make at the commission to ensure that we get the information out, if it is not exempt.
Stephen, I get you, but let's look at this from the angle of...
So
Franca. Yes, Franca, give me a minute. So, following up on what Franca is saying. So, let's say, for example, there's a time limit in respect to the information I need, and we call the parties and we are going back and forth. Would we look at some timelines so that, I don't know, because sometimes when you get the information, it becomes redundant.
So,
irrelevant.
We are implementing the law. The law says that when you go to a public institution to apply for information, the institution has to respond to your application within 14 days.
14 days.
Okay. But then the law also says that where you need the information urgently, okay, you must indicate so in your application and then give a reason for the urgency. And when you do that, then the law ties the institution down to 48 hours.
Instead of the 14
Yes,
days.
instead of 14 days. Okay, but if you don't indicate in your application and give a reason for the urgency, okay, then the institution has 14 days.
The institution looking at 14 days and we coming to you.
Yes.
The law also states that you do not need to state your reason for making the request in the first place.
No, I said the reason for the urgency.
And so if I don't have to state my reason for making the request,
reason for the urgency,
and then now I have to state the reason for my urgency, is that not still me disclosing the reason why I need the information?
No, it's under section 1, subsection 3. In fact, it says that an applicant does not have to give a reason for asking for information.
So if you don't give a reason for it, you are looking at 14 days. But if you want it urgently, you have to.
So no public institution can ask Anita, why do you need this information? No, that is a no-no.
So that public institution will have 14 days to answer if all things been equal.
But then the law says that where you indicate in your application that you need the information urgently, then give a reason for the urgency.
So that they will do it within 48 hours.
48 hours. So let's draw a line. It's not a reason for the information. It's a reason for the urgency. That is what the law, these are not my words. These are the words of the law.
I think Seth wants to come in. Seth.
Yes, is the urgency not tied to certain conditions that must be satisfied?
Yes, it is.
So please tell us those conditions and whether as journalists.
So if it is for the protection of life, okay, and the liberty of a person, okay, these are the broad conditions you need to satisfy. Then you can come within the 48 hours, but only when you indicate in your application that you need it urgently. Okay, yes, you need it urgently, and then you must indicate the reason for the urgency. That one ties the public institution down to the 48 hours. But other than that, the law says, unless it is amended, the law says the public institution has. The law says.
We are all here. We are all here to educate and help.
Yes, the law says.
All right, so Seth, I'm coming to you. So Seth, give me some of the. Give me. Should you want information from a public institution? Give me one of the procedures you used that you were successful, and then you give me another one that you weren't successful. The procedure.
Okay. All right. So. For audit service, for instance,
you really have to use audit service.
Oh yes. I mean, I will applaud the audit service any day for the kind of work they do when the Fourth Estate asks for information. I mean, there is no blockades. The same as SSNIT as well. These two institutions are really doing well. Thumbs up to you. The heads of institutions and the RTI information officers, they're doing a great job. So that particular, in the case of the audit service, it is the information we've asked that help us to do stories that are around the compliance of the asset declaration law, for instance, which has obviously led to a high rate of compliance as we speak. And then also we can talk about the scholarship secretariat. Steve was earlier talking about their mediation role. In that instance, where we asked for the data from the scholarship secretariat, but for their effort, in any day, I will applaud the RTI Commission for how they started their work. I mean, they were really great. Because if it wasn't for their enforcement powers, if they were not active, we would become Liberia. I interact with colleagues from Liberia, and the way they complain about the RTI law, they're appalling. So I would like to applaud them for that. I mean, they stepped in when the scholarship secretariat said that this data is out of bounds because it contains personal data. They said no. Bring the information. We'll verify what you refer to as personal data. And when they did, they engaged us. We had a mediation session, and then they decided that okay, redact things like phone numbers, index numbers, and so on, and then release the information. And had it not been the efforts of the RTI Commission, I doubt we would have been able to do that story, because it took 18 months to be able to get the data. Yes, we were that patient for 18 months before we got the data. And
said, let me remember another important thing that happened in respect of that case. So when the commission got in touch with the scholarship secretariat, their concern was that because they hold people's data, they were not sure whether giving out that information would breach the Data Protection Act. And so they said they had written to the AG for advice, and they showed us a copy of the letter. So the commission, held that mediation session, and we agreed, and we made the scholarship secretariat understand that for a letter that had gone to the AG, you can never be sure when it would come. Right? So this is the best way out. You want to safeguard yourself under the Data Protection Act, just so that you don't breach the Data Protection Act. The commission doesn't carry any liability. Now, portions of the request are statistical. So in the immediate, let's agree. List the statistical aspect of the information. The how many. By tomorrow, give us a copy, give a copy to the Fourth Estate. And then let us have the entire information. So that we would go through and determine which portions of it, just so that you wouldn't have to wait on the AG. So if for 1 year, 2 years, you have still not received your advice from AG, the application would be pending. And as Seth has said, it worked. And for so many of the cases like this is how the commission has been going about settling.
So what if the institution doesn't comply?
If the institution doesn't comply, that is when the commission
gives orders slapping administrative penalties and all that.
And administrative penalties, how much are we looking at there? Is there a penalty unit?
No. So for now, the Act has given the Commission the power to impose administrative penalty. Okay.
At your discretion.
Yes, the LI was coming in to circumscribe that discretion.
So I'll ask that question for him. How far with the LI? I know, right?
But
Don't mind me.
Anita,
Don't mind me.
Anita, if I may land.
Okay, go on, say it.
Go ahead.
Yes, you asked that are there institutions that have refused that information? I would say yes. The security services are notorious for refusing to release information.
No, come under one of the exceptions.
Section 9.
If the application has fined them or not, they refuse, blatantly refuse. I mean, under former IGP, Mr. Dampari, it happened so many times that we gave up. The Minerals Commission, I mean, there was a landmark decision by the ITI Commission when the Minerals Commission refused to give us information and asked us to pay about $1,000. And the commission said we should pay, ITI Commission said we should pay about 2 CDs per page for $1,000.
That was a good one.
Yeah, a great one. It was a decision that I think it puts all these institutions at their smoothness level, and they decided to do what is right. That one, but I think that my major concern with the commission is, like Franca said, how long it takes for the commission to adjudicate on the cases. We think that ideally, the commission, if we have information officers being given 14 days, head of institution 15 days, the commission itself needs some kind of timeline to decide on its cases. It shouldn't take 5 months. It shouldn't take 6 months.
Yeah.
We think that ideally 60 days or maximum 90 days should be enough.
Yeah.
It is because the commission is not being strict on these state institutions. That is why they could decide whether to give you the information or not, even when they are written to. And I agree with Franca that if we begin to surcharge the heads of institutions and the RTI officers in those institutions, they'll begin to sit up. Because I remember when the past administration said that now KPIs of chief directors would include the release of information. I think there was some level of swiftness when you ask for information. There was some swiftness. But when it goes to the commission, then everything goes stale. I mean, you have to wait forever. And for journalists, it doesn't really help us.
Well,
I mean, it stalls your work.
Okay. So, Stephen, why? So now we have 4 questions.
Yes. The commission to decide.
Yeah. So we have 4 questions for Stephen now.
Yes, it's not entirely the case that when the cases get to the commission, they get stuck. Okay, as Franca did indicate, see, there are some of the cases that go through series of back and forth, whether through mediation or exchange of correspondence. Okay, and in fact, we are moving away from the exchange of correspondence. We realize it eats into the time. So we are now doing more of mediation. Okay, invite the parties, thrash out the issues. And then regarding the Act does not give the commission timelines, but these are issues that we catered for in the draft regulations for LI. But it's
you brought the LI
yes, it's unfortunate it couldn't pass, but we did everything we needed to do at our end. I believe Seth knows that we even sought their input. We did all the stakeholder consultation. We did the final consultation with the parliamentary committee. We finalized everything. But for the hold up in Parliament towards the end of last year, it should have passed. But the chairman of the committee at that time was the current Attorney General, Dr. Aine. Okay. And we went through everything, finalized. His report was ready, but then because of the hold up, okay, it couldn't.
So about this year, why wasn't it laid?
So this year is a new government. In fact, I've been asked this question a number of times, and I've been very key in working on this document. Okay, we have lawyers from the Attorney General's department who are part. Okay, so what needs to be do? What we need to do is to have the current Minister for Government Communications, Mr. Felix Ofosu-Kwakye, to write to the Attorney General, okay, intimating that he would like the draft to be relayed. And then we would have to go and meet the new parliamentary committee, okay, and then go through it again, take on their concerns. So that is what has to be done.
They need to be finalized. So when are we looking at? Are there any timelines?
So for now, it is not at our end. We have given that advice. We have given that advice to the minister. Okay.
We do know that sometimes you can force things behind the scenes.
Yes.
But as an institution, you don't have timelines as in maybe we'll do this, if this one, like at least some timelines. So that Seth will know that maybe by next year, mid-next year.
No, so you see, everything is done. So through our executive secretary, okay, we have informed the minister this is what has to be done to bring it back to Parliament, okay, and then we are ready to go and meet the committee, and then so we don't have to do the broader stakeholder consultation again. We've done everything, okay. So hopefully, I think this year is almost ended. Okay, hopefully next year the minister will do that. Just a matter of writing, and we have, but I have been conferring with the lawyers at AG, okay. So they give these directions. The
legislative drafting department.
Yes, they give these directions, which I have communicated to our executive secretary. And I know she has also relayed the information.
So the question I'm having now is, okay, so let's say, for example, individuals can go to institutions for information.
Yes.
And institutions can go to institutions for information.
Yes.
So if I'm an individual and I want to go to a particular institution for information, can you take me through how I should go about it?
Okay, so under section 18, which lays out the application procedure. Then your application has to be in writing.
Okay.
Okay. So whether through email, whatever, it's in writing. But in your written application, the Act says that you must describe the information you are looking for, just so that the public institution can get the information for you. You must also indicate the manner of access. If you want to be given the information, the photocopy, if you want to be invited to come and inspect, okay. If you want further information on manner of access, go under section 28 of the Act. It deals with manner of access, okay. It gives different pictures about what manner of access you can ask for in your application.
But the most general and easiest one will be email.
Yes, a lot of applicants indicate that they want to be furnished with the information in PDF format.
Email,
okay. Yes. Yes, it's all right. So in this written application, you have described the information. You have indicated the manner of access. Okay. You will have to indicate your name, your address, of course, and then you will sign or thumbprint, and then add proof of identity, either your Ghana card, your passport. There's an additional responsibility that if you are applying on behalf of another person, then in addition to all this, you need to indicate the capacity in which you apply for that other person. But you know, see, this is for those who can write. Okay, so for those of us who cannot write, either by reason of illiteracy or disability, under Section 18.2, the law says just walk to the public institution, okay, and then ask to speak to the information officer. And when you are shown the information officer, tell the information officer orally what you want. It is the duty of the information officer under the law to take down your application in writing.
That's good.
Yes, and then read it over to you and explain to you in a language you will understand. And you should appear to have understood before you either sign or thumbprint. But
I'm surprised my time is up.
But then, in this instance, the law says that there must be a witness. So you must go with a witness. And it's the duty of the witness to also endorse on the face of the application as taken down in writing, to attest to the fact that the information officer, after taking it down, read over and explained to you, and you understood before you signed or thumbprinted. So this is the application process, very simple.
Okay, so let me come to you, Franca. Looking at some of the weaknesses of this Act and how it's implemented, what are some of the advice you give, and what will be your final word on this? You are muted. Franca, you are muted if you are talking. Okay, let me come to Seth and then I'll come to Franca. Seth.
I'm here.
Yeah, so my question is, what are some of the weaknesses you've encountered and what do you think is the way forward? Strengthening of the act, the LI will solve it, or what are some of the practical ways and then you give me your final words, all under a minute.
Okay. I think that going forward, we should train the RTI officers more, because some of them appears, in quotes, clueless about the process involving requesting information. I mean, somebody, for instance, tells you, why do you need this information? I mean, that question should not be coming from an RTI officer, because he or she should know that it's a right. I mean, there's no limitation on it if it's not exempted information. That is one. Two, as I said earlier, the Commission's own timelines needs to be looked at in a way that makes it easy for information to be released timeously. Let's put journalists aside. Assuming I'm an academic or I'm a student working on a thesis, and it takes me all these months to move from the institution to the RTI Commission. I may fail and may not be able to complete my thesis, because don't forget, the RTI law is not for only journalists. Third, I also think that the institutions are abusing the fees and charges. Because if you are giving me a document that is in a PDF format, and you want to charge me per page when you are not printing anything, it's an abuse. We have been forced to pay around 650 cedis, 1,300 for data. I mean, how many media houses can afford that? That's an abuse. It should stop. And then finally, I think that it's important that we orient our head of institution from the MMDs to appreciate the fact that the right to information is no longer discretionary for them to decide whether to give you information or not. It is mandatory so far as it is not exempted. It is mandatory. Yeah. They need to recognize that. Thank you very much.
Thank you so much. Thank you so much. Franca?
Yeah, can you hear me now?
Yeah, I can hear you. Thank you.
Okay, so yes, just as Seth said, some of these institutions feel like as if they own the information and have the right to conceal the information. And so some kind of education needs to go around in the various institutions. And I will still repeat the fact that it's important that we look at who is punished, who is made to pay for non-release of information. We need to review that. And then I feel that we did a project called the SARIS project. CDD did a project called SARIS project across a number of districts in Ghana. And one of the tools that we educated people on in the fight against corruption was the RTI law. And we realized that a lot of people are not aware of the law. And so there will be a need to do some education for the larger public to know about the existence of the law, so that we can all be able to test the law and use it to fight corruption. Yeah. Because it's just a few people that are really aware of the law and are using it. Yeah. It will be important to educate the public on it.
Yeah, and I agree. So I agree with Turi so much. So because in my institution, when it came up, I think Seth brought it to my attention. So when it came to my table, I was looking at it. So I went to read around it, and I'm like, this is information everybody should know.
Yes, yes.
Yeah. So Stephen, why is it that everybody doesn't know your final words?
No, we are actually doing so much when it comes to sensitization. Okay, since we started fully in 2021, but by the end of 2023, we had toured all 16 regions in Ghana. Wow. Holding public fora everywhere we go, to which we invited a cross-section of the public, market women, media houses, schools, all public institutions. We did PowerPoint presentation. And it's an ongoing exercise.
Oh, okay.
For the past 2 years, we've been doing church and mosque sensitization. And
You have to come to my church.
Yes, we will gladly come. And we have a whole department whose main duty is to sensitize and monitor compliance.
And they work with NCCE? Like, is there...
Okay, so discussions are ongoing to leverage the connections NCCE
the platform,
has at the base. But almost every week we have a number of days officers move from the commission to public institutions. We avail ourselves. We write to public institutions.
That's great.
Yes. So when you get hold of our annual report for 2022, 2023, 2024, you will see the level of sensitization we've been doing. We go to public institutions.
Maybe you should be moved from a commission to an authority so that you can have more bite than back.
I believe even under the current dispensation, we have. You see, we are now, for the past 2 years, getting to 3 years, we are in Kumasi for Ashanti region. We are in Sunyani for Bono. We are in Bolga. Okay, we are ready to move to Cape Coast. Okay, and hopefully by next year, courtesy the magnanimity of Ghana Broadcasting Corporation, they've availed to us some of their offices in Sekondi, Ho, Kofodia, and Tamale to use. So we have to renovate and use them. And when we move into the regions, our mainstay is sensitization and compliance monitoring. So we've been doing that a lot.
And you use their local means of communication.
Yes. We've been, you know, it is huge. It's a huge mandate.
It is.
When you go under section 44, it says, yes.
Stephen, you're running up.
Yes. It says the commission has to collaborate with other state institutions for sensitization. And we've been doing that. There's a body called ATI division under the Information Services Department. Okay. They have also been doing sensitization, actively on the act. So sensitization is an ongoing process. Now, my last words. This is a law that has come to stay. Seth and Franca did indicate that heads of institutions should be sensitized to know that giving out information is not an option. Okay, it is a mandate. It's mandatory. Okay, the information has been paid for by the taxpayer. Okay, and now there is a law that mandates you to give out information provided it is not exempt. When we go around,
so far as it's a public institution.
Yes, and when we go around,
so the private institutions, they're waiting for now.
No, you see, there's a curious, we couldn't get time to go through that. If I mean to veer into that, there's a curious definition of public institution under section 84 of the law. Okay, it defines public institution as public institution includes private organization or private institution.
So like my church?
Yes.
Okay.
Depending on, so there are two yardsticks under the definition. If you're a private institution or a private organization, it's either you receive public resources or you perform a public function. And we can...
Church, public function?
Yes, okay. In fact, institutions are fighting us in court. There are some institutions we are at the Court of Appeal with. GCB
so I think you have to come and pay me so that I give you a whole session.
Yes.
So in conclusion,
yes. So
in a sentence.
Yes. So in conclusion, we entreat all people to get to use the Right to Information Act to ask for information. That is one sure way to ensure transparency and accountability. Yeah. And the Commission's social media handles are very, very active. Our doors are open 24/7. So you can contact us on our email, rticommission@rtic.gov.gh. You can visit us on our website, www.rtic.gov.gh. You have some of our decisions uploaded there. You can follow the activities of the Commission. We are active on Facebook. We are active on Instagram and all that. You only need to type in Right to Information Commission for LinkedIn also.
You see, so much information. but my main kind in short, near say some public institutions near and some private institutions, even including one sorry. So open information be a ultimate trauma. Now catch up so here some information. Ultimate short me wrap some semi information information in be brain na is some of them out. Kakri pen on ultimate for maybe a security and maybe any personal issue or be or yari and debi. But say institution information ultimate trauma not to me come work some of farmer. Or more farmer ultimate call RTI Right to Information Commission or me puana winya. Issue kakra but afenaba eba ye nche ahibia nti se etimi bua RTI commission omo timi edwuma ne ya etimi apo them omo be ha ye kakra de ba ye test law no na law no air strengthen na fi ye sesa no na fi eyeye nti institution bi o ha question bi o ha pe so obi so sana ko bi sasa institution no me am sorry questions am one dey also ye be start a test law no kakra. So that's what we said so far. All public institutions, if you have any if you need any information from them, you can go to them. Some public, private institutions, including churches, can come under the definition. You go to RTI Commission, their websites, everything is there. Just read around there, ask questions. I think we should test the law. We should test this right to information. We shouldn't just leave it to Franca and Seth and the Fourth Estate and watch. We should as individuals, okay, so that we'll see how far we go. It will help with corruption and all these information. It will help. All right, so until next week, sorry we've spent so much time. Please God be with us.